Under the United States Bankruptcy Code, a debtor seeking discharge of student loan debt must show that the debt will impose an undue hardship on the debtor. In Thomas v. Department of Education, the court considered whether such a debtor must demonstrate a total inability to obtain employment. Vera Thomas, who'd been working at a call center for 8 years, enrolled at a local community college to improve her career prospects. She obtained $7,000 in loans from the United States Department of Education to pay for her first 2 semesters. Thomas didn't return for a 3rd semester, so the loans went into repayment. The following year, Thomas was diagnosed with diabetic neuropathy, a condition that causes leg and foot pain after prolonged standing. Thereafter, Thomas frequently took unpaid leave from her job due to her symptoms, and the call center eventually fired her for violating company policies. Thomas subsequently worked a series of jobs, but had to quit each of them because they required too much standing. Thomas was unable to find a suitable sedentary job, and consequently was unable to pay her student loans and other debts. Thomas ultimately filed for Chapter 7 bankruptcy and received a general discharge of her debts, but the student loan debt wasn't discharged. Thomas filed an adversary proceeding against the Department of Education seeking discharge of her student debt. The bankruptcy court refused to discharge the debt, and a federal district court affirmed. Thomas appealed to the Fifth Circuit, arguing that pursuant to the United States Bankruptcy Code, the student loan debt should have been discharged because it imposed an undue hardship on her.